Now, once again, Raymond Arroyo.
Welcome back to The World Over Live. On Tuesday, the 9 Supreme Court justices spent 90 minutes grilling attorneys in the Sebelius versus Hobby Lobby case. At issue, whether for-profit corporations can cite religious objections to opt out of the mandate to provide employees with contraception and abortifacient coverage. Joining us to analyze the arguments is the original lead counsel for Hobby Lobby, now in private practice, Kyle Duncan. Welcome back to the program.
Thank you, Raymond. Nice to be here.
I want to get your opinion on this. We heard leading into this case and in a lot of the public coverage now, this really boils down to the government extending a right or recognizing a right for corporations. In the Citizens United case, they said corporations have a right to free speech. Here, they're asking whether corporations have religious liberties or religious freedom. You would say what to that argument?
Right. That's really a distraction from the real argument here, which is, can people get together in a business or a nonprofit or a church and exercise religion? Well, we've always thought that they could. Now, a lot of oxygen in this case has been sort of taken up by saying, well, can corporations pray? Can corporations go to heaven?
Does a corporation have a soul? I kept hearing
does a corporation have a soul? You know, it's interesting. When we finally got to the Supreme Court level, those arguments got no traction at all. And I didn't see a single justice who was nodding their heads when the government was saying no for-profit corporation can exercise religion. Instead, I heard a justice like Justice Breyer say, well, you know, what about 5 Jewish brothers who are running a kosher deli or a kosher slaughterhouse, that sort of thing? And what does it matter what their business form is as far as whether they're exercising religion? The two things just don't have anything to do with each other. So the government didn't get much traction with that argument at all. And by the end of the argument, I saw the government backpedaling away from that argument.
Now, tell me how the Religious Freedom Act of 1993, which I remember sadly very distinctly when it was signed, how will that affect this particular Hobby Lobby case?
Well, that statute, the Religious Freedom Restoration Act of 1993, which was signed by Bill Clinton, the claims in this case will really turn on that law. As a matter of fact, one of the first questions that Justice Kennedy asked that I thought was very significant is he asked Paul Clement, arguing for Hobby Lobby, can we decide this case based on a statute as opposed to deciding it on the First Amendment? And the answer, of course, is although the parties have made claims under the Constitution, that statute is extremely important. And that indicated to me, at least reading the tea leaves a little bit, that when the court can decide a case on a narrower ground like that, on a statute, it sort of feels like it's on more solid ground than going out to the Constitution.
And what does it say, very briefly? What does that Religious Freedom Act say?
Right. It says if the government substantially burdens someone's exercise of religion, a person's exercise of religion, then the government has to justify that burden under the highest standard known to law, otherwise known as strict scrutiny. Right. What that means, in normal person speak, is that the government has to have an extremely good reason for doing what it's doing, and it can't accomplish its objectives through any other means at all.
Now, the government is saying, the administration is saying, we are not substantially burdening anybody's religious rights. They aren't being substantially burdened. It's so remote, having to pay for this type of coverage, for reproductive coverage, as they call it, contraceptives and abortifacients, that there's no argument here. You would say what?
Right. It's hard to understand the government's argument on this because what substantial burden has traditionally meant in the law is how much pressure is the government putting on you to do something that your religion says you can't do.
Right.
What the religious exercise here is quite clear. I can't pay for someone else's abortions. Very, very clear. The fines and other penalties that the government is threatening to put on business owners like the Green family are enormous. So there's really no question that there's a substantial burden here, and the government's arguments are just very difficult to understand.
Do the carve-outs that are already in the bill, okay, for certain religious communities, does that undermine the administration's argument here about this substantial burden?
Well, we certainly say it does. And an interesting thing that happened during oral argument is there was a lot of discussion about the so-called grandfathered plans. Now, grandfathered plans, grandfathering was given for pure administrative, maybe even political reasons. You can keep your plan if you like it. Grandfathered plans, which number in the tens of thousands, covering millions of people, don't have to comply with the mandate, don't have to provide any women's preventive services, mammograms, None of that. However, they do have to provide certain sort of politically palatable items, such as letting your children stay on the plan until 26, no lifetime coverage limits. These were popular. These poll well. So Congress said grandfathered plans have to cover those, but not any preventive services mandate. What that says to us is that what the government is trying to accomplish through the contraceptive mandate just really isn't that important.
I want to share with you and the audience some of the arguments that were offered and the questions particularly that the justices had for both sides of this case. First, Justice Kennedy. He raised this point. He said, and this is the quote to Donald Verrilli, the Solicitor General, "Under your view, a profit corporation could be forced in principle. There are some statutes on the books now which would prevent it, but could be forced in principle to pay for abortions." What did this tell you?
Well, I thought this was a devastatingly bad moment for the government's argument. You know, for a lot of the argument, justices who appeared to be against Hobby Lobby were trotting out the so-called slippery slope arguments.
Right.
If we rule for you, then someone will say, I won't cover blood transfusions or I won't cover vaccinations. But then the real slippery slope argument is, what if the court rules for the government? Could it force a group of doctors, say, who are in a for-profit medical practice, let's say they're Catholic doctors.
Right.
Could the government force them to provide surgical abortions? And the government seemed to agree that, yes, the government could do that.
Well, first Verrilli said, no, that's not what we're talking about here. The law doesn't ask for that. But then Kennedy kept pressing him, and Roberts jumped in.
Well, Kennedy kept pressing him, Justice Kennedy kept pressing him. Then Chief Justice Roberts jumped in and said, but isn't that what we are in fact talking about here? According to the beliefs of the families here, aren't we talking about chemical abortions? And the government's answer to that was, well, we agree that they sincerely believe that.
You mentioned a moment ago some of the other justices. This is Justice Kagan who said, referring to her colleague, Justice Sotomayor, she said this to the individual, Paul Clement, who was arguing on behalf of Hobby Lobby. Justice Sotomayor is quite right that there are quite a number of medical treatments that different religious groups object to. So one religious group could opt out of this and another religious group could opt out of that, and everything would be piecemeal and nothing would be uniform. What do you say to that?
Well, with all due respect to the justices, this is what we call the bureaucrats' objection to religious exemptions, which is if I give you an exemption, someone else is going to ask for an exemption, so no exemptions for anybody. That's not how we ought to think of the law. It's not how the court has analyzed the law in the past. What the court has said is hypothetical objections, we can deal with those in the future. There may be fringe religious objections that will never succeed in court, but let's deal with the objection we have here, that so many people around the country have filed suit over.
But
this one.
They've already given opt-outs to the Amish and other groups as part of the original law. So I didn't know what Elena Kagan was talking about at that moment, because there's already a kind of jack-o'-lantern approach here.
That's right. The fact that the government has offered exemptions to so many different groups already on precisely the same grounds as Hobby Lobby and the Green family are arguing about really undermines the idea that, well, if they give this exemption now, the floodgates will open.
The floodgates are already opened.
The exemptions have already been given. I don't know that it's a floodgate at all. It's just the exemptions have been given, so why not give it to these folks?
I want to end with this. This is Justice Kennedy, and he said, in a way, the employees are in a position, and he's the swing vote here, all important. In a way, the employees are in a position where the government, through its health care plan, is, under your view, is allowing the employer to put the employee in a disadvantageous position. The employee may not agree with these religious beliefs of the employer. Does the religious beliefs of the employer just trump?
And of course, the answer is no, of course it doesn't trump. But the government has to show a really good reason to force an employer to provide a specific subsidized benefit to the employee. You know, the government really did double down on this employee rights idea. But when pressed by the court, including by some members of the so-called left on the court, the government could not answer this basic question, which is, if this is so important to employees, can you get it to them? Can you get the drugs to them through some alternative method? The government had no good answer to that.
I want to shift gears. Here at the D.C. Circuit level, there was a major case happening at the same time the Supreme Court was hearing the Hobby Lobby case. And this is the Halbig versus Sebelius. Now, this case I thought was very interesting, and I've sort of been watching this from afar. What this focuses on are 34 states that opted out of the health care plan. They refused to establish what is known as a state exchange, where they would dole out health care in the state. Because they opted out, the government set up a federal exchange there, but according to the law, subsidies to go to poor families and those who need help can only move through state exchanges, not federal ones. They're arguing that the statute itself, the law, just invalidates what the Obama administration has done here. Your thoughts on this and what the implications could be?
This is a very important case because it's not just a technical question about money flowing. Mm-hmm. The way that the federal government incentivized the states to set up these exchanges, which are a very important part of the overall Health Care Act, is to say, we'll offer subsidies to your citizens if they come on the state exchange, betting that the states would take that incentive and set up the exchanges. Most have not. Mm-hmm. And so the government now finds itself running its own exchanges, and the law, at least the way it's written, seems very clear to the challengers, which says subsidies won't flow. So this is a major problem, and as I understand it from the accounts of the argument, the government faced some extremely tough sledding in the D.C. Circuit.
Do you think you think it'll be ruled out of order?
It could be, and in which case it might go to the en banc D.C. Circuit, which has undergone some personnel changes recently, so who knows how that'll come out. Ultimately, the case may have to go to the Supreme Court, and that will be another blockbuster challenge to the Affordable Care Act.
Oh, Kyle Duncan, thank you so much.
Thanks
we
for
will
having
be
me.
in touch with you as this case matures.